Good afternoon, Judge Windell.
Good afternoon, Chief Justice.
How are you?
I'm very well, thank you. How are you?
All right. Have you been waiting for a long time?
It's been a long day, yes, but not so bad, thank you.
Yes. Okay, no, that's fine. Thank you very much for availing yourself for consideration for appointment to the SCA and for coming to this interview. We are going to ask you questions with a view to satisfying ourselves to what extent you are able to meet the selection criteria that have been adopted by this commission for the selection of candidates for appointment as judges at various levels. And you have given us a lot of information about yourself in the questionnaire and other documents here. And we are not going to try and cover all the information in our questions. We'll focus only on certain areas. We are all deemed to have read this information and we'll take it into account when we make our decision. But for purposes of the questions, we will just focus on certain areas. Is that only?
Thank you, Chief Justice.
I will ask you questions and thereafter I will ask the President of the Supreme Court of Appeal to ask questions, then the Minister and then other commissioners. I see that in terms of your academic qualifications, you hold a BUris and an LLB degree, is that correct?
That is correct.
And the BUris was from the University of Northwest and the LLB from UNISA, is that right?
That is correct.
Yes, and in terms of your career, you started as a prosecutor and later you were a magistrate up to 2013 when you got appointed as a judge of the High Court, is that correct?
That is correct.
And so you have been a judge of the High Court since 2013, that makes it what, 11 years now?
11 years, yes.
Yes. As a magistrate, and you were a magistrate for 10 years as well, huh? 1993 to 2013, am I right?
It's actually 20 years.
Oh, I'm sorry, you are right, yeah. My arithmetic. Did you do civil work as a magistrate over those years?
Yes, I actually did exclusively civil work.
Yes.
When I arrived in Potchefstroom in 1995,
Yeah.
I've only done 2 years of criminal work as a magistrate.
Yeah.
And when I arrived there as a young 26-year-old, the civil magistrate has just retired. And
Yeah.
nobody wanted actually to do the civil work.
Yes.
And I was then given that opportunity.
Yes.
And for the next 20 years, I was a civil magistrate.
Yes. What kind of matters did you cover as a magistrate? Did you deal with?
It's basically this, not everything is the same as in the High Court, but a variety of matters. There is the university in Potchefstroom. There are several advocates practicing from Potchefstroom. So the quality of work that came to our division or to our court was of a high standard. For example, we had opposed motions on a Tuesday where we would deal with approximately 18 opposed matters and about 100 unopposed matters. So when I came to Johannesburg and I had to do the motion court, I could cope because it was more or less the same. Obviously, there are fields of law that we don't do in the magistrates' court, for example, tax law. So there are fields of law that I only encountered when I came to the High Court.
Yes, but I'm more interested in the nature of the civil cases that you had. I just want you to assist us to see what was the nature of the different matters that used to come before you, civil matters. Well, I don't know whether debt collection did come.
Yes,
before you?
Section 65A
Section
court,
65.
yes.
Yeah.
Yes.
What else came before you?
So we dealt with ESTA matters, we dealt with PI matters, we dealt with contractual matters, delictual matters. I'm trying now to
Insurance?
think back. Yes?
Insurance law?
No, not insurance law really
okay.
in the magistrate court. Not that I can remember now.
What about collision of cars and insurance comes in?
Pardon?
Collision of cars and then insurance law comes in?
Yeah, that might be. Yeah, we had lots of them. Yes.
Okay.
And
right.
obviously family law, lots of family law matters in the district court and in the magistrates court.
Yes.
So I did domestic violence, maintenance, we did estates, civil
Yeah.
work. Yeah, so there's a variety of matters that I did.
Yes. And then you got appointed to the High Court in 2013.
Yes.
What branches of law did you come across at the High Court that you had not had access to in the magistrates' courts?
Well, for example, the one thing that I thought of today is the tax law. When I came to the High Court, I've never done a tax case in my life. So when I got the opportunity to go to the tax court, I find it quite exciting and interesting. And you'll see from my CV that I've delivered 7 written judgments on tax law. And when I acted in the SCA, I was allocated scribe duties in a tax matter. And that matter has been reported. So that is, for example, one of the fields of law that we don't encounter as in a magistrate's court.
Okay, so apart from tax law,
Yes.
what other branches of law have you delivered judgments on in the High Court?
In the High Court. Let's start with criminal law. So I've done criminal matters. That would be criminal law as well as criminal procedure. Also reviews, criminal reviews that we will get in terms of Rule 53. Then going to civil matters, I've dealt with delictual matters, contract law, insurance law. I've dealt with matters dealing with PAIA, first of all, Access to Information Act and the Promotion of Administrative Justice Act. I've dealt with matters in the family law. I've not had the occasion to deal with equality court matters, but when I was a magistrate, I was a designated person in the Northwest Province that dealt with equality matters, where I've dealt with 16 equality trials. I'm trying not to think of other matters, but it's now escaping me. But a wide variety of different fields.
And administrative law, you have
Yes, sorry,
judgments?
yes, lots of administrative law matters, yes.
Yes. The trademark law?
Not had the occasion to do that, no.
And not patent law either?
No.
Okay. Customer law?
Yes, I have.
You have?
Yes.
Okay. And then you acted in the Supreme Court of Appeal?
Yes, I did.
And in the Supreme Court of Appeal, did your acting stint expose you to other branches of law that you had not had access to at High Court level?
I'm trying to think. I think I did one matter where I was the scribe in a servitude matter that I've not encountered in the High Court.
Yes.
But I've acted for 3 terms in the SCA. I've been allocated 6 judgments, 2 per term, and I've written obviously 6 written judgments, and 4 of them were reported.
Yes. And I would like now to refer you to your questionnaire, in particular question 16.
Is it this one? Yes, sorry.
It's on paginated page 10 of the bundle.
Yes.
If we look at the first case, or question 16 says, list the cases where you have written the judgment, not more than 10, which you regard as being the most significant and why. Can you see that?
Yes, I do.
The first case you have put in there is J versus S, and you then write domestic violence, emotional abuse, repeated messages and phone calls constitute emotional abuse. It is an important judgment that gives guidance to the lower courts and is informative to the public.
Yes.
In terms of giving guidance to the lower courts, do you want to be specific in what way it gives guidance, or on what issue it gives guidance?
Because I was a magistrate, there are very few matters, reported matters dealing with domestic violence. So when I had the opportunity to write a judgment, I decided to make it very practical, because I know that lower courts seek guidance from higher courts. So in this matter, there was the issue of harassment. And I've explained the procedure, and I also gave some guidance to the lower courts as how one should go about, because in that matter, the magistrate excluded certain evidence. So I had to give guidance and say, but because we are dealing here with a specific procedure, it's a quasi-judicial procedure, what evidence should be actually considered when one needs to decide whether a final order should be granted. And I thought that was helpful to the lower courts.
Yes, and then in number 2, case number 2 is City of Cape Town. You then say, finding that NERSA is an organ of state, failure to comply with the requirements of Section 41 of Constitution and provisions of Intergovernmental Relations Framework Act 13 of 2005. Then you say judicial overreach. Apart from saying you made a finding that NERSA is an organ of state, and then that there was also failure to comply with the requirements of Section 41. I'm not sure what you are saying here reveals the importance of the case, because remember, the question wants you to tell us what's important about this case. I'm not sure when I read this.
Yes, maybe it was too cryptic. What is important about that case is that I found that NERSA is an organ of state in the sphere of government. I did some research before I wrote this judgment, because this was a point in limine that was raised. And I then did some research, and I found that there has not been a judgment where NERSA, that's the energy regulator, has been found to be an organ of state in the sphere of government. And therefore, the Framework Act actually applied to this matter, because the point that was raised is that it does not, the point in limine should be dismissed, because NERSA is not a state of organ in the sphere of government. So that's why I thought this was an important judgment.
Why was the finding that NERSA is an organ of state important?
Because there are many matters where the energy regulator is a litigant, and I found that they are bound to the Framework Act, and they must try and resolve their dispute as an organ of state before they can approach courts.
Yes, and then the next one is number 3 in Chongwana. You say mental incapacity, implications of failure to testify.
Yes.
There are many occasions when courts have pronounced on the implications of failure to testify.
Well, I was
so
a scribe
why
in
was
this.
Significant?
Sorry, Chief Justice. I was a scribe in this matter, and you would be surprised that there are very few cases dealing with where the accused failed to testify, and how one then approached the onus that is on accused, because you will remember that there's an onus on the accused to satisfy the court that he is not is incapacitated. So I thought this was an important judgment because none of the cases that we researched, and you will see from the judgment, none of the cases dealt with this specific factual, with these specific facts.
You see, the questionnaire requires you to tell the commissioners what was important about the case.
Yes.
If you take this one, if you look at what you said here, I want to suggest to you that really there's nothing that reveals why it's important, because you said so little.
Yes, I apologize for that. I apologize for that. I realized that it's too cryptic. I thought I should keep it short. So I apologize for that.
And then number 4, right, Clough, you say court's duty in eviction applications, not business as usual. Armchair approach not suitable. Well, I think there are more. It's just important that you answer these questions properly, because there's a reason why the questionnaire requires you to give us those cases which you consider important, and to tell us why they are important, because that enables us to see that you have been involved in really important cases. That's the kind of experience you have. But when you don't give enough information that reveals their importance, it doesn't help you.
I accept that.
Okay. Would you like to share with the commissioners your understanding of the doctrine of separation of powers?
Yes, there are 3 arms of government, and basically what it means is that each arm of government has a specific function, and one must be very careful that you must stay in your lane and not tread in another field of arm of government. So basically that's what it means.
And the rule of law?
The rule of law, basically, if I can put it just shortly, nobody is above the law. It's also in terms of Section 1 of the Constitution, one of the founding values. And for that reason, everybody is bound to the law, even government, every single person in the Republic of South Africa.
President of the SA.
Thank you very much, Chief Justice. Good afternoon, Justice Windell.
Good afternoon, President.
Yes, you mentioned that you acted at the Supreme Court of Appeal for 3 terms. Is that correct?
That is correct.
And it was 3 consecutive terms, right?
Pardon?
Was it 3 consecutive terms?
No. The first time I acted was in 2022, from the 1st of June up to the end of November. That was 2 terms. And then I was invited back last year for the 3rd term. I acted from the 1st of June until end of September.
Okay, thank you very much. So how did you find the environment, and how did you find the transition from being a judge of the High Court to being a justice of the Supreme Court of Appeal?
It was definitely different. I want to compare that to when I first came to Johannesburg. As a magistrate, being in Potchefstroom for 20 years, when I first came to Johannesburg, it was a big adjustment, because there are people that think when you come from a magistracy, you don't actually belong in the High Court. So it takes a lot of hard work, and I'm not saying you must convince people, but I mean, for me, it's important that I show that I am worthy to be there. So with the first time when I also arrived at the SCA, I felt myself also have that same feeling over again. You know, here I am, what a privilege, the pinnacle of my career. It was such a fantastic thing that happened to me. And I think the first 6 months I was sort of on a cloud. I found it extremely intellectually challenging. But I loved it. I loved the fact that we are all there. We're all from different provinces. We are working very hard. You can have wonderful conversations with colleagues. The colleagues were all very nice. I made very good friends there. And I also learned a lot about myself. And that's why I wanted to compare that to the first time I came to Johannesburg, because then I realized that I have a voice, that I can contribute when we are in conferences, when we are in court. Questions that are asked, they are valid, they are good questions. So I think for myself, when I went back the third term, I actually settled down, and it was a wonderful experience.
Did you have any difficulties in crafting your judgments?
No, no, I'm not that I can recall.
Did other colleagues have to give a lot of input in your judgments in terms of matters of substance?
No, I'm not. My first language is not English, so when a colleague that is first language is English and tell me that change that word, I'm going to change that word if it makes it better.
I'm referring specifically to matters of substance, not cosmetic or stylistic issues.
Yes. No, I'm not that I can recall.
Yes. And you were there for 3 terms. You now know that the workload in that court is quite enormous.
Yes.
You are also aware of the loss of expertise that the court has experienced due to attrition in terms of elevation of some judges to the Constitutional Court and retirement of others.
Yes,
you are
that's
aware
correct.
of that, yes. In fact, the collective experience that has been lost is estimated to be over 150 years in actual fact. You'd agree then under those circumstances is very, very important for experienced colleagues with broad skill set to be appointed to replace those who have left in order to complement the expertise at the court. Would you agree?
Yes, I do.
So I note that you have been a permanent judge for 11 years. Is that correct?
That is correct.
Yes, and that prior to your appointment, you were in the legal profession for 20 years. Is that correct?
Yes, in total, I've gotten 29 years as a presiding officer. That is almost actually 30 years.
Yeah.
20 years as a magistrate and 10 years as a judge. Yes.
10 years as a judge, so approximately 30 years experience. That being the case, what special attributes would you bring to the table at the SCA in terms of your contribution as far as the judicial experience and the skill set is concerned?
Well, I'm now 56 years old. I've got 35 years of experience. 2 years of that 35 years as a prosecutor, 33 years as the presiding officer, 3 years in the criminal court, and about 31 years in the civil section. I bring with me a wealth of experience. You can give me any type of matter, and I will be able to conquer that matter and deliver a judgment. I've got a judicial temperament. I think my work speaks for itself. I've got the ability to listen to parties, and I deliver my judgments in most cases within 3 months.
Yes, and in response to the questions from the Chief Justice, you mentioned that you have had exposure to a variety of work in the legal field, but you have not yet had exposure to trademarks. Is that correct?
No, I've not had the opportunity.
Yes. At the Supreme Court of Appeal, did you get an opportunity to participate as a panel member in a shipping matter?
No.
Not yet. Okay, last but not least, do you think collegiality is important in an appellate court? I know that in response to that question, some would say that collegiality in general is always necessary, but I'm speaking with specific reference to the Supreme Court of Appeal as an appellate court, where you'll never ever sit alone, in any case. You'll always be with other with other judges, either in a panel of 3 or a panel of 5? Would you say that collegiality is very important
Yes,
in terms of the
absolutely.
functioning of the court?
Yes, absolutely. Because you're working in teams of 5, it is very important to get along with your colleagues. And we've got different personalities. It might happen that because my personality, you don't like my type of personality, that there might be an issue. But when it comes to work, you have to put aside all your differences and you have to work as a team. And I think it's of utmost importance in the Supreme Court of Appeal.
Yes, you said you wrote 6 judgments at the SCA. Were they produced promptly? In other words, in accordance with the norms and standards?
Yes, they were all delivered promptly.
Have you ever contributed to the delay of another colleague's judgment in terms of maybe delaying to give input and so forth?
No, definitely not. I think that is because a person has put so much work into that judgment. When that judgment lands on your desk, you have to put everything aside and attend to that judgment.
Thank you very much, Justice
Thank you,
Windell.
President.
Thank you, Chief Justice.
Minister,
I've got no questions, CJ.
thank you. Commissioner Marmohai.
Thank you very much, CJ. Good evening, Judge.
Good evening, Professor Marochmagai.
Thank you very much. I need to talk to you about one of your judgments that I read sometime last year. And for some reason, it has been troubling me. So perhaps maybe we can have a discussion about it. It's Gruskin versus Gruskin.
Oh,
The one
Graskin,
for
yes.
leave to appeal that was granted by the Supreme Court of Appeal to the full court.
Yes.
Yes. Let me just ask this question. In your judgment, you say that a court that grants leave to appeal, it is the court that should be approached to deal with the issue of security of costs.
Yes, because I think it's Rule 4913 that specifically says that the court that grants leave to appeal should deal with, actually not order security for costs, because that is actually, the rule says they must provide security for costs, except if the court relieve them from that duty.
Yeah, the problem is you answered before I asked the question.
Okay, sorry.
And that's where the problem is. Because
Yes.
if you look at the uniform rules of court, Rule 1 defines a court in a particular way.
Yes,
And Rule 14 and 13 deals with a court as defined in Rule 1.
yes,
Right. And when one applies for leave to appeal, that has been refused by a single judge sitting at the High Court. You apply for leave to appeal based on Rule 17(2)(b). You don't apply for leave to appeal based on any rules of any court.
Are you talking about when it goes on petition to the SCA?
Yes, to the SCA.
Yes,
When
yes.
a single judge refuses leave to appeal at the High Court,
Yes.
you don't have anywhere to go but unless you apply for direct access to the Constitutional Court. But nonetheless, to the SCA.
Yeah, so my reasoning was when you approach that single
I would
judge.
like to ask a question.
Sorry, Professor.
Because now, so that you can answer. Now, when a single judge who has just refused leave to appeal in the High Court, and now you are forced to go to petition the SCA, my question is this. When leave to appeal is refused, that means there is no obligation that arises for anyone to do anything. In other words, the matter dies. If no one approaches the Supreme Court of Appeal, that means the matter dies a natural death.
Yes.
What I want to understand is, how then does, and you might be wrong, you might be right, and
Yes.
I'm just satisfying my curiosity. How then does an obligation to pay security of costs arise when you are applying to the Supreme Court of Appeal in terms of a statutory provision and not the rule? That's the conflict that I have in my mind, because if leave to appeal was granted, then I would have been forced to furnish security for costs because
Yes.
I'm within the realms of 49(13).
Yes.
Then I have to, unless I ask the court to excuse me from paying them. But now, if leave to appeal has been refused, and there's no obligation that arises anyway, if I go to the Supreme Court of Appeal, because Rule 9 of the Supreme Court of Appeal says the party who's brought to the Supreme Court of Appeal can actually apply for security for cause if he or she or it wishes to do so. So my question is, when leave to appeal has been refused by a single judge in the High Court, how does an obligation to pay security of costs arise? That's where I'm like, when I read your judgment, and again, your judgment, there is another judgment, Alem versus Bard. And in your judgment, you don't deal with it. And the judge in that judgment deals with this question. So that's where my confusion is a little bit.
Which matter do you refer to?
Alem versus Bard. You refer to it in page, in your judgment. I beg your sorry, Chief Justice, this is taking longer, but I think it's really important.
Yeah, okay.
I'll tell you now. You refer to it in paragraph 8 of the judgment. It is in paginated page 7. Oh, paginated page 133.
One?
No, man, it's paragraph 8 of the judgment. It's paginated page 134. Yes, line 1, 2, 3, 4, 5, 6, 7, 8 from the top. You refer to it. You just say, Dr. Maureen Allen versus Bard. The court found that Rule 49.3a does not infringe the right to access to court, and you leave it there, and you don't deal with the. And I'm not saying that you ought to have dealt with it, but it was surprising to me, because the judge in this judgment decides something different. It deals with the question of how Rule 49, subsection 13 is not applicable when leave to appeal has been granted by the Supreme Court of Appeal. And I'm not saying that I'm right and you are wrong. I'm just debating with you. I just want to understand.
Listen, this was a very, very interesting matter to me. It took me some time to come to the conclusion. And in my view, if you read further, I explain why I say if a single judge refuses leave to appeal, obviously the question of security will not arise. But now they petition to the SCA. The SCA grants leave, say, back to the full court. So again, if you then go back to the full court, you are bound by the uniform rules of court, which is Rule 49. And Rule 49 says, before you can lodge your appeal record, you must furnish security. So that was my reasoning, that even though the SCA, when they grant leave to appeal, does not excuse the plaintiff or the person that's appealing from providing security, if you look at what the rules say, as soon as it's back in our courts, that is the High Court, they will have to provide security in terms of 49.13. Otherwise, the appeal will not be able to continue.
But the court defines, the uniform rule defines a court in Uniform Rule 1 as a court as understood in Section 9 of the Superior Court Act, and in Section 6 of the Superior Court Act. And Section 6 mentions the High Court and all of its divisions. It does not talk about the Supreme Court of Appeal. And that's where my confusion is at, as to how then, when there was no obligation, when the single judge refused leave to appeal, and the rules of the Supreme Court of Appeal specifically deals with the issue of security for cause, if anyone desires them, then the court, because remember, when you're applying to the Supreme Court of Appeal, you don't know what the Supreme Court of Appeal will do. It might say we want to hear the matter, or it might revert back the matter back to the full bench.
Yes.
My fundamental question.
Let's try and bring it to finality.
Yes, I will. I think I make a point that I can leave it there. Thank you very much.
Something you can't resolve yet. Okay, all right. I didn't see any other hands. Therefore, we have come to the end of this interview. Thank you very much, Judge Windell. And
Thank you, Chief Justice,
for availing yourself once again and for coming to this interview. You are now excused.
Thank you.
Thank you.